Hello, I'm Vince White. I'm an employment attorney and I'm answering publicly posted questions on abo.com. And here's the question: can an employer refuse a doctor's note limiting the hours of work to just 8 hours if the reason is based on type 2 diabetes? This is in reference to type 2 diabetes that has been diagnosed 2 to 3 months after hire. Employer is a certified nursing home. The schedule has a rotating double shift if someone doesn't show up. My doctor, upon diagnosis, provided a letter limiting work hours to 8 hours per day. Before this week, the employer has obliged the note. Okay, so they've been doing it up until this week. This week, however, they have reinstated the double shift on my schedule. I was able to work 8 hours fine, but the doubles I cannot perform as they won't provide adequate, timely breaks, and the night shift really messes with my levels. I presume they mean their sugar levels, right, for the type 2 diabetes. Okay, so here's the question, because you're asking, can they do this? So when you apply for reasonable accommodation, the employer owes you two things. First and foremost, they have to have the reasonable accommodation dialogue, right? They have to talk to you, and this is under the federal law. You may have additional rights under local and state law, but under federal law, under the Americans with Disabilities Act, this is what they owe you: a reasonable accommodation dialogue. They have to go back and forth with you saying, okay, what do you need? This is what you need as per your doctor. Can we do it? Is it reasonable for us to do it? And they have to look at, is this accommodation reasonable in these circumstances? Can we do it? Can we accommodate you? Then, if it's determined they can accommodate you, they owe you that accommodation. Here, you're in a bit of luck because they did accommodate you, proving that they can accommodate you, making it a little bit harder for them to argue in the future that they can't accommodate you, that it's not reasonable, because they already did, right? So you're in a pretty good position here. It's not a slam dunk, right? They could still prove somehow that it's not reasonable. I don't know the specifics of the job situation, right? It's possible that they could prove they can't reasonably do this. I'm just saying you got a bit of an advantage because they already did. They already proved they could for at least a little while, so why can't they keep doing it? So it does sound like you might have a claim under the ADA, Americans with Disabilities Act. You may have additional claims under local law. I would recommend speaking to a local employment attorney. Certainly, you may have a claim, although it doesn't sound like you really want the claim. It sounds like you want the accommodation, so you keep working here, and an attorney can probably help you with that as well. Although, keep in mind, if the attorney's not winning you money, if they're just getting you the accommodation, they might charge you money, right? Because they can't take a percentage of what they win for you if they're not winning you money. I hope this helps. If it does help, consider liking, subscribing, even commenting below, whatever you want. It really helps me to help more people just like you.